Good morning, everybody. We have now the fourth panel of this workshop, and we come to the definition of the crimes, and then the following will be again definition of the crimes. We are dealing now first with war crimes and aggression. The following panel will deal with crime against humanity and genocide. We have a speaker, which is Dr. Acquaviva, who was working at the ICTY, and then at the Lebanon Tribunal, then again the Tribunal of Kosovo, and now he's working in the Organization for the Prohibition of Chemical Weapons in The Hague. So he's online, I think, and he will have, he's already there, yeah. And he will have 20 minutes, maximum of 20 minutes to give his exposition on the definition of the crimes. So please, Guido, you have the floor.
Thank you. Can you hear me well? Yes. Thank you very much. Thank you very much for this invitation. I'm honored to be invited to speak on this topic in this high-level conference. My reasoning will be a rather short one, and we'll move along the lines of trying to understand what is the situation in terms of definitions and applicability of these definitions in the Italian legal system of war crimes in particular, and in part also aggression. Just as a general presentation, and I think some of these elements have already been discussed yesterday and even this morning by Professor Zimmerman. The whole system of domestication of international crimes within national systems, of course, depends on the single national systems to a great extent. And in Italy, I would like to start, although one could start much earlier, but I would like to start with the law number 6 of 2002, which has attempted to revolutionize, but actually only touched very lightly on the so-called War Military Criminal Code, the Italian Military Criminal Code for Times of War, and in particular its Article 165 that provides this amendment a kind of a cornerstone of the reform. And the new text of Article 165 says that the provisions of this title apply to all cases of armed conflict, independently of the declaration of the state of war. This comprehensive wording implies that war crimes can now be of relevance to any armed conflict involving Italy, that is both international and non-international armed conflict. It's been said that Article 165, in a sense, acts as a gatekeeper, expanding the war crimes provision to all or most relevant contemporary scenarios, including Italy's involvement in operations to support local governments around the globe. So when this article is applicable, this would cover war crimes generally. However, we remain with the situation that the definitions of war crimes contained in the War Military Criminal Code are definitely inadequate, and Italy is still suffering from a lack of serious implementation of the Rome Statute and of its international obligations under both treaty law and customary law. In fact, Professor Bartolini has stated that pursuant to a principle of strict legality in criminal matters embedded in the Italian Constitution, all international provisions that establish new criminal offenses are non-self-executing and therefore cannot be directly applied by the Italian judiciary. That has been the practice so far and will most likely continue to remain the practice in Italy. The only slight improvement was provided by Article 185 bis, which was added in 2002 as well. And this provides that the soldier who commits acts of torture or other inhumane acts or other acts prohibited by international treaties is punished with a sentence of between 2 and 5 years. This is actually potentially an instrument through which Italian prosecutors and Italian judges could apply directly any international crime that is included in an international treaty ratified by Italy, and could therefore, because there is an explicit reference in an act of parliament and in Article 185 bis of the Military Criminal Code. Of course, this would allow for a conviction, but the sentencing in most cases would remain ridiculously low, as between 2 and 5 years. In theory, this article could also be used to criminalize directly, even without an addition to the criminal code, aggression in case of ratification and acceptance by Italian Parliament of the amendment on aggression. Again, it would be extremely limited. It would be a route that is probably not necessarily the preferred route, but it would be a possibility. It would be a possibility only for military personnel. The article refers to soldiers, and it would again impose the sentence of a maximum of 5 years. Of course, this just very brief introduction shows why legislation similar to the German one, and for instance among the lines of the Cariplo project spearheaded by President Pocar, is really paramount. There is an essential need to move towards that type of comprehensive domestication of international humanitarian and criminal law. What is very good, and I think completely new in terms of the Cariplo project and other similar endeavors, is the fact that the Rome Statute, as we all know, defines war crimes on the basis of a very artificial distinction between international and non-international armed conflicts, and other artificial distinctions that provide cumulative and a doubling of certain offenses that is completely inefficient and to be honest, even difficult to understand for the interpreter. And these projects have the merit of really focusing on the protected legal interest and dividing and therefore dispensing with most of the artificial distinctions that still exist for some reason in the Rome Statute. However, allow me to use this as a starting point for a larger discussion that is a bit of a provocation that I have expressed in the past, and knowing full well that its nature is the nature of a provocation. Article 25 of the Italian Constitution reads that no punishment may be inflicted except by virtue of a law in force at the time of the offense. And this is, of course, the nullum crimen principle. And Article 10 of the Italian Constitution reads that the Italian legal system conforms to generally recognized principles of international law. There is no doubt that the duty to punish certain crimes is enshrined in customary law, as well as in several treaties to which Italian Parliament has authorized ratification through law. Importantly, I think at least two treaties to which Italy is a party, that's the ICCPR and the European Convention of Human Rights, provide that law in relation to the nullum crimen principle can be interpreted as including customary law. This was accepted actually by our parliament through law itself, because when the Italian parliament ratified the authorized ratification of these treaties. In a sense, one could say that this interpretation of law is the authentic interpretation of what law means in Article 25 by relying on Article 10 as well. So that we give this international, with this constitutional provision of Article 25, an internationally oriented outlook. Moreover, of course, as I mentioned, we have international norms binding Italy to prosecute international crimes. We all know all the various cases before the European Court of Human Rights that have allowed, that have at least said that it is not a violation of fundamental human rights to issue convictions for conduct that was an international crime at the time it was committed. Thus, my provocation is that Italian prosecutors and judges could, in theory, decide to define law as contained in Article 25 of the Italian Constitution as not just being acts of Parliament, but considering Articles 10, 80, and the interpretation by the European Court of Human Rights as being broader than simply acts of Parliament. However, I mean, I fully recognize, and we need to fully recognize that the Italian Supreme Court's position, for example, in a judgment of July 2012, clearly state that Article 25 entrusts on an exclusive basis to the legislative power of the choice as to the conduct to be punished and the overall sanctioning regime. This interpretation clearly prevents an Italian prosecutor from charging individuals on the basis of international crimes that have not been fully internalized or better domesticated by Parliament through a specific crime-creating norm. Allow me to add another consideration to this line of reasoning that I am setting out as this provocation that was suggested to me by Professor Castellaneta when she suggested that I should look more carefully in Italian Constitutional Court judgments when developing my argument. Article 24 of the Italian Constitution reads that anybody, and that doesn't limit it to Italian citizens, it says anybody can act before judicial authorities to protect their own rights and legitimate interests. In the famous Constitutional Court judgment 238 of 2014, and our German colleagues might be particularly aware of this judgment, the Italian Constitutional Court said that this is one of the supreme principles of our constitutional setup. So my provocative question is, why should the right of victims to seek judicial remedy, to act as civil parties in a criminal case, a right that is constitutionally guaranteed, and the Constitutional Court has said that it's one of the supreme principles of our legal system that should never cede, it should always be protected. Why should these rights of victims necessarily and always cede to one of the possible interpretations of Article 25 and nullum crimen principle in our constitutions? Aren't we maybe using a too formalistic understanding of nullum crimen to deny victims of serious international crime their constitutional right to act as civil parties or to be otherwise recognized as victims in trials related to gross human rights violation? A different interpretation of Article 25 might actually allow Italy avoiding breaching its obligation under international law to prosecute certain international crimes. And if a military judge or prosecutor were at a certain point to raise it, at least this might lead the Constitutional Court to provide guidance on the legislation required in this area and its parameters. I am perfectly aware that it's extremely unlikely that the Constitutional Court would say that international customary law can directly be applied, but at least it might be called to define the parameters of any legislation that needs to be passed in this area. And as Professor Amoroso also has shown in an interesting paper, Italian courts, even the Supreme Court of Cassation, have often used international treaties to interpret to the detriment of the accused certain provisions of Italian laws that stem from international obligation. They've used the Istanbul Convention, the Palermo Convention, various UN Security Council resolutions, even the OECD Anti-Bribery Convention. There have been cases in which courts have allowed themselves to use international provision not to convict somebody directly under international law, but to water down, so to speak, the restrictive elements, for example, in the crime of torture as a consequence of the infamous G8 summit violences, using European Court of Human Rights case law. I'm almost, I can almost finish my provocative reasoning and almost leave it at that. Allow me just one final remark. We have a general provision in the Criminal Code of Italy, that is Article 650, that provides that it's possible to punish anybody for not adhering to a lawful order of public authorities, which is a very general reference to any lawful order by any public authority, allowing criminal law punishment. This provision, for example, was used during the recent lockdown. So there was a restriction to the freedom of the individuals protected by the Constitution, the freedom of movement, and this was enforced through a decree of the Prime Minister, and any violation could be punished under these very general referrals by law. Can we really say that knowingly breaching a lockdown is fully within the understanding of the nullum crimen principle, but, for example, devastation of cultural heritage is not, only because the Italian Parliament has not specifically domesticated the international crimes of destruction of cultural property or many other international crimes set out in the Rome Statute or in customary international law. I'm not sure that we are really focusing on the right perspective necessarily in these cases. I'll leave it at that for the time being. I would be extremely happy to hear the other interventions, and if there are questions at the end, to answer any question. Thank you very much for your attention.
Thank you, Guido, for this intervention and also the provocative reasoning, which may raise the debate. We have 4 discussants, actually. So the first is Professor Bartolini, to whom I give the floor. I ask discussants to remain strictly within 10 minutes maximum of intervention. Please, Giulio.
Thank you, Mr. Chair. Thanks everyone for inviting me to this very interesting panel and conference. So basically, I've been requested to take part of the discussion dealing with the panel on war crimes and basically I will focus just on war crimes, and that's my area of expertise. I don't want to discuss so much about what are the current shortcomings of the Italian legal system with regard to war crimes, mainly to the fact that these points are quite crystal clear. I already addressed it in a paper which was shared with it. And basically, it's just a mess, the Italian legal system dealing with war crimes. There have been, as we know, a series of attempts to improve the system, the time in which, for the first time, the wartime military criminal code was used for the first time during the operation in Afghanistan in 2001. So there was very few efforts which tried to make some basic changes made in a hurry way, which does not provide with a satisfactory legal system. So basically, as we know, there are the current system is based on the idea that there is a specific section in the wartime military criminal code which deals with war crimes, mainly based on the text adopted in 1941, which by chance, to some extent, they also cover some, for instance, grave breaches or current crimes which will be criminalized, also having in mind the Rome Statute. But there was not, of course, any systemic reform in the past. The Harry reform introduced in 2001 had the advantage to permit application of the current text both in international and in non-international armed conflict, but with a series of shortcomings that it's totally useless, let me say, to discuss now, basically because the system need a huge reform. So my only point, I will only address 3 points in view of any potential reform that we would like to discuss, from my opinion. So the first point will be the scope of application on any reform in this area. The second point will be the types of war crime that should be included in any potential reform. And the last point will be who should be prosecuted and by whom. So dealing with the scope of application, it's now taken for granted for sure that we should address both, of course, international and non-international armed conflict, and that's quite easy. I think that's something that could not, of course, be made of any significant objection. Also, in light of the fact that already from the 2001 reform, even non-international armed conflict are covered by the Italian legal system. The main challenge would be, of course, to have a proper definition of armed conflict in this regard in order to avoid some challenges. For instance, if you pay attention to the current definition, Article 165 of the Wartime Military Criminal Code, it includes a definition of armed conflict which is not fit for international material law. It's not fit for particularly international armed conflict because it introduced, for instance, a temporal element for the application of the relevant section of the code, which is, of course, at odds with the basic definition of international armed conflict based under Common Article 2 of the Geneva Convention. At the same time, also the definition is at odds with, for instance, with regard to Article 3, Common Article 3 of the Geneva Convention. So we should handle with care the definition of armed conflict in order to avoid a potential wording which will be not in line with international maritime law, as it is currently the case. At the same time, I would be very skeptical to introduce some wording like the one introduced in the Caripol project, under which it refers that the current title also applies to military operation carried out by the armed forces outside the Italian territory under the aegis of international organization. This could be a very misleading wording because it might appear as providing competence for potential crimes, even if there was not a belligerent nexus. On the contrary, of course, we know that you can apply war crimes only in case you have an armed conflict, there is the belligerent nexus. And so the idea that you can apply this, like in the Carpo project, to any military operation could be misleading. Mainly because, and that's also a risk that I already face in light of the current system of the wartime military criminal code, which already includes a provision which affirms how, pending a reform, that's the word, the provision of this title shall also apply to armed military operation carried out by Italian armed forces abroad. Also in recent cases, I already discussed with military judges that wanted to apply, for instance, the military criminal code, for instance, to the case of the Italian Marines, the Erika Lexi case, mainly used this point. Of course, you could not, let me say, use the crime of murder, which of course also included as a war crime, in scenarios which were not linked with an armed conflict. So there is a reason why, for instance, the Erika Lexi case is under investigation by the common, let me say, criminal judges in Rome, but the military judges also started to open investigation and to discuss the point whether they should have competence. So my basic point, if we want to have something about war crimes, we should handle with care potential extension beyond the context of armed conflict, as it should be very, very misleading. The other point would be, second point, types of crimes to be included in any potential reform. We already discussed yesterday with Coco what could be the solution. We can pass and copy from the ICC statute with an easy minimal approach, which will be already be very significant in light of the current shortcomings, or we can have a sort of adoption of autonomous solution to be creative in order to follow some trends in current system of international criminal law. From my perspective, the idea that we can also merge the potential between international and international conflict and also extend the potential war crimes to something which are not included in the ICC statute and provide criminalization at the domestic level is something already granted in our legal system. We already have in our legal system a series of crimes in the military criminal code which goes beyond even the ICC statute. Just for reference to criminalization of people stealing personal belongings or for violation of freedom of religions or stripping a corpse or whatever in international conflict. You already have the potential extension of crimes not qualified as war crimes by the ICC statute, of course, made on a totally random way in the current legal system, and can, of course, go further, but we must be also in this case handle with care any potential reform. Just an example from the Carpo process, when we would like to criminalize attacks which are against the principle of proportionality. We know the rule under the ICC statute requests that the damage to collateral damage should be clearly excessive in relation to the concrete and direct overall military advantage. If you read the Carpo process, you don't have clearly anymore. You just have excessive, which is, of course, the IHL provision, but it's not the international criminal law provision as it stands in the international, in the ICC statute. And I can quote other examples, for instance, dealing with damages to the environment. And the Carpo project adds, for instance, able to disrupt the life condition of the civil population, which is something not in the ICC status. So if we want to go further, I think we should be very rational and understand why we should go farther than what is the current list of war crimes. It's possible, but I think we should avoid just to make some mistake. Plus, I'm also in favor, already as said by Guido, the idea to have potential omnibus provision for future war crimes. We already know through Article 185 bis how it's possible to criminalize also other conducts which are prohibited by international convention. This is very broad, from my perspective, provision. I'm a bit skeptical to try to use it to fill any potential shortcomings. But in a potential global reform, of course, to have this sort of open clauses might permit to follow some future potential development in international law, even if the risk would be to criminalize everything through such provision, also something which probably is not a war crime yet. Final point. Prosecution by who we should prosecute and by whom. So basically, in this regard, we know the current system only permits prosecution by acts committed by members of the armed forces or by enemy armed forces against Italian citizens. In this case, of course, we should be careful in order to include potential perpetrators, including members of the armed forces, Italian, but also foreign armed forces, but also members of organized armed groups who might commit acts against Italian citizens or Italian members of the armed force or civilians. And then, of course, we should discuss how far should be the principle of universal jurisdiction applicable in our legal system. And final point, by whom? That's the basic point. So who should have the competence for war crimes in any future reform? Should we have just a single judge, like the common criminal judge, or we should take into account what the Constitution says about? The Constitution, Article 103, says that military tribunals in times of war have the jurisdiction established by law. They use the expression in times of war, which is totally different from state of war, which is something different. So we don't need a state of war to give jurisdiction to military tribunals. We can also say that law and our future reform will say they don't have competence. The competence is zero, and so all crimes will go to common judges. But if you want to be strategic, I think we could not leave military judges outside any potential reform, because otherwise, if the idea would be that your competence for any potential reform would be zero in this area, even if the Constitution says that you can have competence in this case, and even the Constitution says you can even have competence against civilians in times of war, the Constitution could permit even this point. My suggestion would be to put them part of the discussion and eventually, based on the same offense, which should not be different, give competence in some cases to military judges, because this could bring a relevant stakeholder in line with any potential reform and favoring. And also, we should take into account how current trends are probably going to extend the notion of military crimes. There are bills pending the parliament now, which would like to extend military crimes in peacetime. So my idea to strip military judges from competence of war crimes will be for me a hurdle for any potential reform. And I close with that. Thank you.
Thank you, Professor Bartolini, for your comments on how to introduce war crimes in the Italian system, actually, and how to proceed on these matters. We have now Professor Cancio Melia from the Universidad Autónoma de Madrid. He's online. So,
thank you, Professor Pocar. First of all, even if I only have 8 minutes according to schedule, I would like to thank the organizers, Professor Chantal Meloni and Florian Jesberger, also Maria Kripa, for this very stimulating workshop, and to think that a common criminal law theorist might have something to say in this very specialized area. So I thought it to be my task to speak about the Spanish situation on war crimes. And I will start with a decision that was issued a year ago by the Audiencia Nacional in Madrid, where a former colonel of the El Salvador Army and Vice Minister of Defense was convicted for the killing of Spanish priests that were located in El Salvador since many years ago in 1989. This responding to the principle of authoritarian judiciary, because the Salvadorian courts wouldn't do anything about him. So he was detained while in the United States and extradited to Spain. This person was convicted, is now in prison in Spain, was convicted for crimes of terrorism for these 5 killings that he ordered by a special commando unit of the then El Salvador Army. This might be quite surprising, and it's not only due to the terms of the extradition that were accorded by the United States, but also related to the Spanish approach to the war crimes and other international crimes, in my view. It is well known that the Salvadorian army of the moment had a strategy that included massive commission of war crimes against civil population. And of course, the killings could have been rated as crimes against humanity. But the conviction took place for crimes of terrorism, of state terrorism, which is very interesting from the perspective of state terrorism. Why did this happen? It happened not only because of problems with the legal certainty principle derived from the legality principle, since Spain enacted these offenses in 2005. It was not related to the problem of legal taxativity, being this ley penal blanco, a white, empty definition of the crime, of black catch-all, because it is related to the general approach of Spanish legislation to these international crimes, including war crimes, which could be described as a model of hypocrisy, in my view, of course. So in the minutes I have left, I will first refer to the substantial aspects of Spanish criminal law related to war crimes or crimes in armed conflict, and then make some statements regarding jurisdiction. And the contrast between these two issues will show us why I am speaking of a structural, hypocritical regulation in Spain. If we look at Spanish criminal law, we have a very, let's say, international crime-friendly approach. There is no distinction, as we have seen before, that generates problems in other jurisdictions, between international war stricto sensu and other instances of armed conflict, which are much more often to be seen in the territory of a state. The definition of the crimes that are incorporated into the criminal code is completely dependent on the relevant conventions. So that if we had to stop here, we would say Spain is complying with the idea of an effective enactment of international crimes, including war crimes, perfectly. But in an especially intense bias of what has been called in the day of yesterday, the risk of a class justice. I would say that if we go to the second point, what is the jurisdiction regarding the universality principle, we see that this, what we can read in the criminal code, notwithstanding the problems that could exist with the legality principle, because the referral to the relevant conventions when it comes to the definition of crimes is complete, and that could be in conflict with the constitutional case law regarding the legality principle, as we heard from other jurisdictions yesterday also. The problem is that we have this only on paper, and it is designed to stay on paper. The development of Spanish criminal law after the national Catholic dictatorship, as regards the expansion of the criminal court's jurisdiction over the crimes recognized by public international law, in accordance with the principle of universal jurisdiction, can be divided into three phases. In the first one, from 1985 to 2009, the principle of universal jurisdiction applied with no limits, that is, with none of the restrictions to the jurisdiction of Spanish courts based on the existence of a link between the crime and Spain that might have existed, very favorable to the effective existence of these international crimes. In the second phase, from 2009 to 2014, the Spanish court's jurisdiction was severely narrowed by the requirement that one of such links must exist, especially through the principle of passive personality. That is the precondition that at least one of the victims be a Spanish citizen. Thirdly, and finally, a recent amendment which came into force at the beginning of 2014 and which was adopted by the Spanish Parliament through an accelerated proceedings against the backdrop of the ongoing investigation against leading members of the Communist Party and the Chinese government for human rights violations in Tibet, and towards members of the religious community of Falun Gong. This new enactment de facto abolished the principle of universal jurisdiction in Spain, especially in that it also put into question the possibility to initiate preliminary proceedings in these fields on the grounds of an actio popularis, a Spanish form of prosecution that is open to any citizen. I must try to summarize to keep in time, but as we have learned from WikiLeaks, there had been strong pressures from the Israeli government and from the US government regarding instances of war crimes committed against Spanish citizens in the invasion of Iraq, related to the action of the Israeli government in Gaza, and so on, in addition to the Chinese cases. This was, and we know it, it's not a presumption, has triggered that the both most important parties in Spain cut down the jurisdiction of Spanish courts in such an intensity that made all of these international crimes, including war crimes, to be just on paper, in my view. In this regard, and I will close with this, it seems to be of particular importance to note that the lack of any limits to the principle of universal jurisdiction in its initial recognition in 1985 strongly contrasted with Spain's specific coping mechanism concerning the crimes committed during the almost 40-year-long dictatorship under General Franco. Indeed, from 1936 to 1975, the national Catholic dictatorship perpetrated in Spain thousands upon thousands of murders, other crimes against humanity, and also war crimes, especially during the Civil War and shortly thereafter. This contrasts very, very strongly after a statutorily declared amnesty under the threat of picking up the guns in 1977 by the military, that the first phase, when some investigating judges would take up cases from Latin American dictatorships, seem to be very strange. How can one point out the dirt under the rug of other states while keeping thousands of corpses in one's own basement?
Professor, may I ask you to conclude your statement?
Yeah, yes, of course.
Yeah, because it's good.
The upshot of this story touches upon different areas. It is very difficult to honor the demand to prosecute international law crimes worldwide is clear. And in the case of Spain, we don't have an evolution that could be seen as positive in my view. Thank you very much, and excuse the excess.
I thank Professor Cancio Melia for having clarified the situations concerning Spain. And I now give the floor to Professor Della Morte. Please try to keep within the time because we are a bit out. So please.
Thank you very much. Just let me very short thanks to Professor Meloni to have organized this very interesting workshop. I will present some very short observation on the topic of aggression, in fact, which is probably, in my opinion, the most difficult topics, even in terms of implementation, execution into the internal legal order. Now, the crime of crime that has been adopted into the statute of the International Criminal Court officially since 17 July in 2018 was represented by Benjamin Ferenc, I remember, at the opening ceremony of the Kampala conference as a trick. You know, why did Benjamin Ferenc qualified the aggression as a trick? I don't know if you can remember the definition of the Article 5 of the statute previous in relation, the first definition, the first qualification of Article 5 before the Kampala conference. Article 5, paragraph 1, letter D, say that the International Criminal Court has jurisdiction over the crime of aggression. But paragraph 2 say that the court, I quote, will exercise its jurisdiction over the crime of aggression once a new disposition will be adopted. That's why Benjamin Ferenc called it a trick. With the right hand, I give you the crime. With the left hand, I give you away the jurisdiction from that crime. Now, during the Kampala conference, apparently the trick was eliminated. And they re-established, after a long negotiation process that I cannot summarize right here. I have written extensively on that, unfortunately in Italian, but if someone is interested on that topic, I would be glad to share my reflection on that. But after the Kampala conferences, yes, they adopt a definition and a working definition of aggression, but two main issues remains. And I would like to ask to Dr. Acquaviva what he thinks about and what could be the effects on the domestic legal order of that problems. These problems are relating to the qualification, Article 8, and the jurisdiction, the trigger mechanism in relation to the aggression. Let me start with the qualification. Article 8, crime of aggression, I quote, means the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct the political or military action of a state of an act of aggression, which by its character, that means kind of qualitative test, or gravity or scale, which means kind of quantitative test, constitute a manifest violations of the Charter of the United Nations. Under paragraph 2, for the purpose of paragraph 1, act of aggression means the use of force, etc., etc., means the application of the international law, and especially the Chapter 7 of the Charter of the United Nations. Now, apparently, we do not have particular problem with this definition, but we stay at precisely at the crossroads between the jus in bello and the jus ad bellum. And this could cause main problems. Because even the Security Council, in some manifest situation of a violation of aggression, just let me give just one example, the aggression from Iraq of Kuwait, that was absolutely an aggression from all point of view. But the legal qualification of that act that was incorporated in a resolution 660 of the Security Council was the Iraqi invasion of Kuwait, not an act of aggression. And the same in a lot of different occasions, the Security Councils used some periphrases. For instance, act of armed aggression, provocative and aggressive act, but they almost never use the word aggression. So my first question relating to the definition is, Dr. Acquaviva, do you think that if playing with the complementary regime, a national judge used the definition of aggression, that could have some kind of even informal impact on the international definition? That's the first question. Second point, I will be very shortly. The topic of the exercise of jurisdiction. That was the main second topic that was discussed during the Kampala conference, probably the most problematic one. Two main questions arise inside the problem of jurisdiction on aggression. Which role you have to assign to the Security Council? If the Security Council have a red light power, a green light power, a mixed combination of these two different powers. And the other is, which role do you have to assign to the consensus of a state party? If a state which is already party of the Rome Statute but don't want to be party of the amendment of aggression could escape from the jurisdiction over the aggression. That was the second main point. Now, what the Kampala compromise said on that topic. Article 15 ter, the Security Council that referred the situation to the prosecution under Chapter 7 could activate. So it has a kind of green light power. And Article 15 bis paragraph 4, which is probably one of the most problematic disposition of all the corpus juris of the Rome Treaty, the court may exercise jurisdiction under Article 12, means under territorial and national criteria, unless the state party has previously declared that it does not accept such a jurisdiction. Now, as far as I know, just two states have given a declaration under Article 15 bis paragraph 4. And if I well remember, has to be Kenya and Guyana or Guatemala. But my question in relation to the implication of the ratification of aggression is, do we have into the legislative process, into the academic discussion, a position on that? I mean, are we discussing this kind of topic? Are we discussing which will be the position of Italy in relation on of this very specific problem? That's it. Thank you very much.
Thank you very much for pointing to the difficulty of introducing in the system aggression, the crime of aggression. And now we move on to the last discussant, which is Professor Scoletta of the University of Milan, and I give him the floor.
Thank you, Professor Pocar, and above all, thanks to Professor Chantal Meloni for the invitation to take part in this panel in such prestigious context of two experts of international criminal law. As a criminal law scholar perpetuating the legacy of classic criminal law, I question whether, in the lack of explicit legislative provision set by the national law, we can prosecute war crimes and, in general, international crimes based on international customary law and according to the rules set forth by ratified international conventions. According to the established interpretation of Article 25 of our Constitution, which set forth the nullum crimen principle, criminal offenses can be defined only by a law approved by Italian Parliament, which is the only institution allowed to take choices in criminal matters. The underlying rationale is the democratic foundation of the choices of criminalization, which must be the direct expression of the will of the people and therefore of the parliament. This is what I will call the lex parlamentaria principle. Thus, according to Article 25 of the Constitution, customary law is not a sufficient legal basis for prosecuting war crimes in Italy, because every single criminal offense and every single penalty shall be discussed and approved by the Parliament. It is true that Article 7 of the European Convention of Human Rights and Article 15 of International Covenant on Civil and Political Rights instead generally refer to law as a legitimate source of criminal liabilities, to potential including customary law. Nevertheless, ratifying those treaties did not imply the overcoming of the traditional meaning of Article 25 Constitution. Why it is? Because setting aside the lex parliamentaria principle would amount to a limitation of the democratic side of the guarantee and the rule of law in criminal matters, and would then be in contrast with a fundamental principle of Italian Constitution. But let us admit for a moment that the lex parliamentaria principle is not absolute and it can be balanced against other constitutional rights. Even assuming this perspective, I don't deem for example, Article 24 of the Constitution as an constitutional basis for derogating the lex parliamentaria principle. Article 24, paragraph 1 states, all persons are entitled to take judicial action to protect their individual rights and legitimate interests. But this only means that the legislation must grant any person, of course including the victim of war crimes, to right to an effective remedy, not that the remedy must be institution of criminal proceedings, even that the victim can also claim compensation through civil proceedings. In my opinion, a more suitable constitutional basis for limiting the lex parliamentaria principle could be found in Articles 117, 11, and probably 10 of the Constitution. That's the provision that respectively allow international conventions, EU law, and customary law to produce effects in our legal order. Through this provision, the positive obligation to criminalize serious aggressions to life and physical integrity set forth in customary, international, and EU law can turn into corresponding constitutional obligations to criminalize such acts. However, such obligations cannot be understood as constituting individual and immediately justiciable rights, as if they were directly applicable provision of EU law. As positive obligation, they require a positive action of the state, that of the legislator, aimed at instituting the legal framework to prosecute such aggression, including the signing of appropriate criminal provisions. The state's lack of action in this respect may well result in its international liability, but it does not allow prosecutors and common judges to criminalize a certain conduct on the basis of international obligations that have been ratified, but have not been transposed in our legal order through appropriate criminal law provisions. In this perspective, whatever we like it or not, I personally don't. The Parliament's reluctance to codify war crimes and many other international crimes may reveal the persisting absence of a full democratic consensus on such choices, and the presence of various political interests pushing against such legislative projects. And such reluctance finds its legitimacy in Article 25 of the Constitution. Finally, even setting aside the theme of the lex parlamentaria principle, I would question the customary law can be understood as a direct source of criminalization of war crimes, even under Article 7 of European Convention on Human Rights. From a formal viewpoint, it may be well acceptable that the concept of law enshrined in Article 7 encompasses customary law. But then the substance of the nullum crimen guarantee, that's the lex certa principle, come into play. Article 7 requires that the law, every kind of law, be sufficiently precise and must not be applied analogy, not retroactively. Can we really agree that customary law respects those principles? I'm very doubtful in this respect, given that we all know that customary criminal provision, as well as many criminal provisions set forth in international conventions, generally leaves the states a wide margin of appreciation in defining the exact outlines of international crimes and corresponding penalties. It's true that European Court of Human Rights, Kononov and Makuf judgments, have deemed customary law as sufficient legal basis for punishing war crimes under Article 7 of the Convention. However, such a conclusion has been widely discussed by criminal as well as international law scholars. The mere fact that various European court judges have expressed dissenting opinion and that the chamber itself had reached an opposite conclusion in Kononov show that the definition of what is war crime and customary law and which are applicable penalties is far from being set and therefore raises precision and foreseeability issues. So, in conclusion, the problem is not to establish in abstracto whether customary law is law within the meaning of Article 7, but to ascertain in concreto whether customary law is foreseeable and accessible law under such provision. Thank you for your attention.
Thank you, Professor Scoletta, for this intervention that goes to an issue that was raised by our reporter Acquaviva. Now I would ask Guido, do you prefer to have some words now, but a short answer, or wait for a 10 minutes discussion we may have with other interventions from the floor and then take the floor at the end to answer? Which is your reaction?
I can wait. There is no preference. So maybe the The debate first is good. I have no preference.
Okay. Yeah. So I take notice of this that you have no preference actually. So I think as we have a short time now for the debate, I would prefer to get some questions now, and then Guido will answer to questions. Our friends here will do it, and Guido will take the word for a final statement. Please. I see. Yeah. Please be concise in the interventions because we have a very limited time now.
Thank you very much. Thank you very much, Marco Longobardo, University of Westminster. I was wondering if Dr. Acquaviva could elaborate a little bit on his reflection on the potential of Article 24 of the Italian Constitution as a remedy against the lack of criminalization of certain conduct. Because in my reading of Article 24, access to justice, there is the right to have access. There is no right to have criminal proceedings.
Dell'altro.
Okay, I'll try again. I was saying that if I was wondering if Dr. Acquaviva could elaborate on the potential of Article 24, because in my reading, Article 24 of access to justice doesn't mean there is a right to have a criminal proceeding against the offender. In fact, when it was invoked as the supreme principle of the Italian Constitution, we were talking about monetary compensation, maybe at the end, I don't know, in the famous case 238 that Dr. Acquaviva mentioned. So how could this article help us to have a criminal prosecution when there is no crime in the domestic system? Thank you.
Thank you. Other questions? Yes, please.
A short question as well. So it's a question to M.Scoletta, but I think for everyone. So there is a kind of conceptual antinomy, I think, between the requirement of a lex parlamentaria, a statutory basis for criminal liability, and universal jurisdiction. So what is the logic to insist on the idea that only national parliament can establish the elements of a crime and the applicable sanctions if we endeavor to apply domestic criminal provisions implementing international criminal law standards to acts committed by persons who have no link with the national parliament and its choices? The only logical basis for applying these provisions to them is to rely probably on another concept of legality based on international law and on foreseeability of the consequence of their conduct based on international law and not on what Parliament had decided, because Parliament can decide for Italy, for Italian citizens, but not for a person in Salvador or for a person in Argentina. So the logic underlying the principle of legality in extraterritorial jurisdictions must be linked in a way to the international law and not to the lex parlamentari. So I'm wondering how this could be reconciled with the teaching of the Italian Constitutional Court, of which I'm a member, of course. But I mean, there is a kind of logical conundrum which needs to be addressed and solved, I think. So it's just a reflection.
Thank you, Professor Vigano. please there. And then Herman.
Thank you. Thank you for the panelists. My question goes to Professor Cancio Melia. I was curious about this concept of state terrorism because recently I reflected also on the application of German crimes of terrorism to state actors. And you mentioned it briefly in the presentation of your case of the Salvadorian general, ex-general. Could you maybe just quickly elaborate whether there were discussions and how it came, like, recognized that these crimes could be applied also to state actors? Thank you.
Thank you. Herman, please. Yeah.
Thank you. My question is exactly the mirror image of Christopher Burkhardt, and goes to Professor Bartolini and Professor Cancio Melin, because is there in your jurisdiction any tendency to lower the threshold for an armed conflict? We know since the ISTY Tadich that it has to be protracted, yes? And if you perhaps lower it, for instance, the case of Bataclan in Paris, you could consider perhaps terrorists as war criminals, yes? And would it have any added value, because then you would be able to apply the international humanitarian regime to that particular situation?
Thank you. Any other questions? If not, I will give the floor to the discussants quickly to answer questions directly to them. Maybe Giulio, you can take this last question.
Yes, no, just got the last comment. Yes, it is on. Yes. So basically, no, my idea is that we must be strict on what are the proper definition of armed conflicts, and particularly for non-international armed conflict, I will definitely stick on the current definition that we also got in the new commentary of the Geneva Convention. And so we definitely need to rely on definition which, for instance, deals with organization, with intensity, and no more. So basically, my assumption would be that the definition of armed conflict we should introduce in the Italian legal system in any potential reform should just defer the definition to the international legal order, rather than try to include an autonomous definition. Currently, the autonomous definition included in the Italian legal system is at odds with international humanitarian law. For instance, it requires a military organized and extended use of arms, which of course is fine, for instance, with the ICC statute, is less fine with Common Article 3, but it's definitely contrary to Common Article 2. So the idea to customize the definition of armed conflict in the domestic legal order is could be misleading, and so that's the reason why I definitely prefer to leave it to the evolution also, which might occur at the international level without try to anticipate it or to lower in order to have something which is unfit for IHL.
Thank you. And now, then I will give the floor to Guido Acquaviva to...
Thank you. Thank you very much. I hope you can hear me. I received a couple of comments and I would like to react to those. The first one was a very intriguing comment on the qualification, and in particular on the crime of aggression, and whether Italian judges, if Italian judges were to apply this. I think, I mean, it would be difficult, definitely, and it would be difficult to, in my view, to foresee how a prosecutor and eventually an Italian judge would apply the crime of aggression. We know, of course, that, for example, in the UK, both in the Jones case in 2007 and more recently in 2017, another case, applicants have argued that the crime of aggression, as defined by the IMT in 1945, were part of the domestic common law, and the House of Lords in the first case and another court more recently dismissed the argument. So they kind of recognized the existence of an international crime according to the definition given by the IMT, and or as developed by the Rome Statute, but then refused to apply it in the specific circumstances of the case because the UK Parliament had not adopted implementing legislation. So I think we would find ourselves in a very similar situation in Italy. Having said that, in light of the principle of complementarity, I think a dialogue between domestic courts and amongst domestic courts and between domestic courts and the ICC in particular would be quite interesting in developing the contours of an acceptable definition of the crime, which is very complex definitely after the Kampala amendment. In relation to Article 24 and more generally the very expected but very crushing comments by Professor Scoletta as a criminal lawyer and scholar vis-à-vis my previous provocations, I think I can link the two comments. I think that there is definitely the scope for different interpretations. I'm just relying on the fact that the Constitutional Court in 2014 called Article 24 and the right to judicially act to protect one's rights as one of the supreme principles of our constitutional setup. Article 24 says that all persons are entitled to take judicial action. It doesn't say only in civil cases. And so why would a supreme principle? The answer would be, of course, it's kind of a provocation as well, but the answer would be why would a supreme principle of the constitutional setup have to be limited implicitly by something that is not there in the text of the Constitution, and therefore, if I choose to act as a victim in a criminal case, why should I be limited in this? And I would like to link this with the completely fair comment by Professor Scoletta of the fact that there is the Parliament acts as a bulwark in a sense of democratic legitimacy, and you need to have law by Parliament to execute this type of international crimes. Well, I mean, again, let me add provocation to provocation. We have a law of Parliament that requires to give full and complete execution to the Rome Statute. So why aren't we relying on the will of Parliament that said very explicitly the President of the Republic should sign the Rome Statute and full and complete execution should be given? This is not full and complete execution if a victim cannot have a criminal case. So we are either Parliament was lying, it was not really full and complete execution, or we could interpret the law authorizing ratification as referring to the crimes in the Rome Statute and therefore to the rights of victims. Again, provocation added to provocation. I'm completely aware of that these are heretical views, and I'm not sure that I even myself believe them, but I'm actually quite sure that I don't believe them, but I wanted to set them out anyway. Thank you.
Thank you, Guido. I forgot one question that was directed to Professor Cancio Melia, so I give him the floor if he's there.
Well, very briefly, there is a gray zone between crimes against humanity and crimes in armed conflict and terrorism. But the solution that was taken by the Spanish court in this El Salvador case was forced by the fact that the United States had extradited this colonel only for the killing of Spanish citizens, of these priests, Jesuit priests. So it is in this context that I was happy to see my own position on this reflected in the court's decision, because it would amount to narrow this gray zone to distinguish between the activity of a state, terrorism, state terrorism, from the activity of certain organisms, of certain structures within a state, terrorism from the state, which is judged under national law, not under international law. So it is a good moment from my perspective that the Spanish Audiencia Nacional has taken this position, but it contrasts starkly with the fact that the state terrorism from the state in the dirty war against ETA in the 90s wasn't declared by the Spanish Supreme Court as being constitutive of Spanish offenses of terrorism. But at least we have this for facts that happened thousands of miles away from Spain. And the idea that I have promoted in some writings that there can be terrorism exerted by state structures, by police, army forces, was accepted. Thank you very much, Professor Pocar.
Thank you. And this concludes our panel discussion. I wish to thank all those speakers, both in the panel and in the audience. And we have a coffee break.